So this is all about exploring the relationship between collective actions and competition law. And the headline point is there's a very strong relationship between class actions and competition law. Just very, very briefly to make some introductions. So I'm Sam Ward. I sit in the litigation practice at Clifford Chance, and I focus on all forms of antitrust litigation, follow-on litigation, standalone litigation, and collective claims. Pedro, I don't know whether you wanted to briefly introduce yourself, and then perhaps Helder?
Yes, sure. So my name is Pedro Fernandes. I'm a lawyer in Lisbon with the VDA litigation practice, and I deal with antitrust claims, product liability also for the past 10 years or so.
Hi, my name is Helder Vasconcelos. I'm Senior Vice President at Compass Lexecon and head of the newly created office in Lisbon. I'm also a full professor of economics at the University of Porto, and I, of course, work on a wide range of antitrust issues, including class actions, of course. Thanks.
Thank you both very much. So I think the structure that we thought might be helpful here, because we each have a different role in terms of the jurisdictions we're involved in and the issues that we grapple with, we'll probably each spend sort of 5-10 minutes giving an overview on the issues that we see and then perhaps dig into some of the detail from there. So I thought I'd start with a relatively brief overview of what we're seeing in the UK. And it's worth noting that outside of competition claims, we see a healthy amount of group litigation in the courts. So just very briefly, in the High Court, we have environmental, ESG-based claims. We have complex financial services claims, securities litigation, shareholder investor claims. But there's no doubt that it's the competition law regime that is driving the collective action space in this jurisdiction and, of course, globally. And that it's the competition side of things which is consuming a lot of the noise and the attention. So what are we seeing here in short? So we have a specialist tribunal, which I'm sure we're aware of, the Competition Appeal Tribunal, which we call CAT. And at the moment, we have something like 53 collective claims in CAT. And the collective value of those claims, just doing some pretty rough maths, but reasonably good maths, which I didn't do, just to reassure you, is that the total value of damages is in the region of £100 billion, which is pretty staggering. And obviously a number of those claims are spearheaded and driven by litigation funders who effectively allow these claims to happen. The claims are diverse, so they touch on a range of sectors, so financial services, tech, unsurprisingly claims against Google, Meta, Apple, but also touch on regulated industries like telecoms, rail, waste, environmental, etc. What we're seeing, which is generating a lot of interest, are overwhelmingly opt-out claims. So all of the claims bar one are opt-out claims. So, you know, you're deemed in the class unless you proactively take yourself out of the class. Only one is a pure opt-in. There's a very big question about what the future of opt-in competition claims is going to look like, and will there be any in the future. The majority are also standalone claims, so there's no relationship with a pre-existing decision by a competition authority. It's a claim that effectively comes out of the blue. And drilling down a bit deeper, and where I think competition law is becoming really interesting and really relevant, is that a number of those claims are abuse of dominance claims and alleging exploitative abuses. And that's where it's getting controversial. And those cases draw inspiration from the excessive pricing cases that the Competition and Markets Authority have pursued here against pharmaceutical businesses. So the allegation, in short, is that various pharmaceutical businesses have excessively charged for certain products and have abused their market power in doing so. So those claims are poaching that theory of harm. But as a result, there's a feeling, at least here, that competition law theories of harm are being stretched beyond their natural bounds, as I say, particularly in relation to exploitative abuse claims. So just to give you a couple of very quick examples, we have a claim against Meta by the claimant Representative Gormsen, which, as far as I understand it, alleges that, again, Meta's abusing its dominant position because users' access to Facebook and social networking services is unfairly contingent on them making vast amounts of their personal data available and accessible by Meta. And of course, you and I and everyone else doesn't make any money out of making our data available to Meta. It's just a precondition of using the site. And that equates to, so the theory of harm says, it equates to effectively an unfair payment in kind. And as I say, in abuse of a dominant position. So that's one example of what I think is considered to be a relatively novel case. Another is a claim against water companies, where the allegation is that water companies have misreported certain types of information to their regulator, for example, about pollution levels and volume of pollution levels, and that as a result of that misreporting, they've been somehow able to charge consumers higher prices. That's a just distillation of what the case is. And I think those types of competition claims are raising eyebrows here about, as I say, whether competition law is being stretched unnaturally. Why does it all matter? And it'd be really interesting to get Pedro's views in a minute about what we're seeing in Portugal from this perspective. Why does it really matter? It's because it's very hard to get these cases filtered out at an early stage. They're all being certified. The bar for certification is extremely low. The test in brief is really this process test, which is now very well known. But what the process test is really testing is the extent to which the claim is triable. And what the claimant representative has to do through an expert report is address three things. Firstly, the theory of harm. Secondly, how that theory of harm causally relates to the class, and so how it relates to the class on a class-wide basis. And thirdly, what the roadmap or blueprint is for working out the quantification of damages across the class. But the critical point here is that parties have numerous bites of the cherry to effectively improve their case. So on the Gormsen Meta case that I just touched on, Meta have been criticised a couple of times by CAT for not really articulating their claim very clearly. And they've had an opportunity to go away and effectively improve their claim. And they've had their claim certified. So the bar is extremely low. And as a result, there's a lot of discussion around whether these are genuine competition collective actions or are they really just consumer claims shoehorned in to a competition theory of harm. And I would say that's what's dominating the discussion here. With that in mind, Pedro, it would be interesting to get your perspective on what you see in Portugal in terms of the types of claims that you're seeing, the types of legal arguments that are being run, and I expect there are differences between the UK and Portugal in a number of key regards.
Yeah, sure, Samantha. I would start by providing a context of the Portuguese regime. So sure. Basically, we have for like 30 years class action regime in Portugal that works. It has worked for Meta cases, for Facebook, for Apple, not competition related. And we also had for like 15 years private enforcement actions in Portugal not related to class actions. So what has really changed in the last couple of years, last 4 years, time passes, is that class actions and private enforcement has mixed. It finally has clicked, and we started seeing class actions with private enforcement in Portugal. So the first attempt to do it was back in 2015. There was a group of professors of the University of Lisbon that founded an association and tried to pass a private enforcement class action in Portugal. It went terribly. 10 years have passed and they haven't been able to do anything, partially because they tried it before the transposition of the private enforcement directive. They have done it prior to the creation of a competition court in Portugal. They have done it without money. So there was not funders in Portugal paying lawyers, paying the technical teams, paying the experts that need to be on board. And that changed in 2018 when the transposition of the directive, of the private enforcement directive, finally happened. That group of professors of the University of Lisbon evolved to a different association, now properly funded, and shortly after, a barrage of private enforcement claims started in Portugal. So you saw MasterCard being sued for more than 400 million in Portugal. You had Superboc, which is a brewer company, the biggest one in Portugal, for another 400 million. Then you had EDP, which is the incumbent of the electric sector in Portugal, also in the hundreds of millions of claim, and always on excessive prices type of cases. So then you have Apple, Google, also in the abuse of dominance position, being claimed in Portugal. The amount of what is being claimed is not public, but I assume it is also in the range of thousands of millions. Then we have PlayStation in Portugal, also with 200 millions. Then we have the cartel with Mel, which is the incumbent of the communications in Portugal. Then we had the biggest, most recently in this year, 2024, 12 banks of the ranging like 19% of the Portuguese market were sued by, which is an excessive price in 3 different markets: housing, companies, and private consume of goods. And this last one is on the 5 billion euros amount, so it is pretty big. More recently, we have, like this month, we have the first hub and spoke private enforcement action in Portugal, so parties are being served at this moment. So we have a ballpark figure of around 10 billion euros being claimed in class actions alone regarding to private enforcement in the last 4 years, which is very significant for a market like the Portuguese one. What is a main characteristic of these claims is that they are all opt-out and they are all standalone. So an explanation for this, the opt-out is very easy to explain. The system is opt-out, so the claim is opt-out. But the standalone is a bit weird because you should assume that claimant would want to rely on a decision of the public authority, be it the European Commission or the authority, the competition authority of Portugal. But that's not what's happening. And I believe that 3 or 4 factors are contributing to this. First one, a fear of the statute of limitation that is driving claimant to put forward standalone claims. Then I believe that some pressure from funders is also being exerted in Portugal, and so this association is going standalone because simply it needs to show some sort of work to the funders. And then I believe that there is a fear of missing out and another association being created and somehow replacing them on the market. And just to complete this analysis of how things are, although claims are moving a little bit faster before the competition authority, we haven't had a proper trial on the merits in any of these cases. So we are dealing with standing, we are dealing with document production phases of some sort. We are discussing some part of expert analysis I mean, a lot of discussion. And then I believe that the competition court in Portugal was a bit, it is short of human judge. Simply, there aren't enough numbers in judges in teams helping the court to help manage this huge amount. The court is completely overwhelmed at this stage. So to set the scene in Portugal, we have a lot of actions. We have important claims being requested by claimants, and we have a court that is more or less overwhelmed, which means that lawyers have a lot of work. Experts will also have a lot of work. By the way, most of the Portuguese lawyers here present are dealing with the deadline to oppose this banking claim. So everyone's very nervous. So and Elder also. So I would pass the ball to Elder if Samantha.
Yeah, just a couple of. I absolutely want to hear from Helder. You look very relaxed for people that are nervous, I must say. A couple of just reactions, just so we sort of tie the threads a bit as between our relevant jurisdictions, which is really interesting. It's probably more in common than I thought. We have the same view on the growth of standalone litigation, Pedro. The reality is it's not a criticism of the regulators here, but the pace of enforcement is just much slower. Investigations just take a long time. And of course, the CMA can't take every case that lands on their desk forward. And by the time issues are raised, you've already got a litigation funder book building a claim on the private litigation side. So private litigation is the weapon of choice, which I think is a huge shift from when I started out many years ago, when it was all follow-on litigation. So completely resonate with that. it's also worth noting just on the UK side that we're in the same kind of place. We've had lots of complex procedural skirmishes, really important procedural skirmishes involving economists. I'll come on to in a moment. But we haven't had any substance, any determination on the substance. So we've had one major trial, La Passerelle, involving BT, with I think last year, and the judgment on that is due to come out in a few weeks or months. But until that, no determination of the substance following trial. And then just lastly, similarly, we have CAT completely underwater dealing with all these claims. And of course, we haven't got time for it now, but one of the big repercussions of these 53 huge claims being certified is that CAT has been quite inventive with its case management powers and is doing all sorts of things to try and break claims up, sequence the determination of claims, etc. Because just as you said, Pedro, it's, they're just drowning. And these are vastly complex claims with only a limited number of judges. Turning to the economist's role, it goes without saying, Helder, that, the economists, can I be honest, are very much the star of the show here. They are. I mean, they've always been to some degree, but particularly in building the theory of harm or defending the theory of harm, from cradle to grave, economists are not just crunching numbers and thinking about quantum, they're case building or case defending from the get-go. And as we mentioned when we caught up a few weeks ago, one of the interesting developments here is that economists are now being asked to even have a role in shaping disclosure and helping the court determine what are the relevant issues from a documentary perspective. So the economist is very, very much in the driving seat. Really interesting to get your views on the role of experts and economists in your jurisdiction. What are they doing? What are they thinking? What are they worried about? Would be fantastic, Helder.
Thank you. Many thanks. Well, I don't know if we are the stars of the show. We try at least to contribute as much as we can.
Well, we're all the stars of the show. Let's make it clear. We're all the stars.
At least the best we can. Just a preliminary note, very brief, just to put the problem in perspective. From an economics point of view, class actions are clearly an economic response to a market failure. Okay, and they are seen as an instrument that can be used in order to correct alleged harm that results from a given conduct, and the conduct here will involve some anti-competitive practice. So the exact point in which we can help is to try, well, if you want to correct something, first you have to understand whether there was harm and whether the conduct had or not a substantial impact on some victims or alleged victims, and that's exactly the point in which I think we can give our contribution. So I would probably highlight three main dimensions in which I think our contribution is valuable, so to say. The first one, of course, is to try and assess and characterize the best we can the counterfactual scenario. This is, I think, a key point of any process, and it's a delicate process because basically you have to predict what would have happened in the absence of the conduct, okay, in the same market. So I usually say that we are in a very delicate position because we are predicting not the future, but we are predicting the past, and we are predicting a past situation that did not occur and will not occur. Okay, so it's a very delicate situation. In order to do that, the main instrument we use is econometric analysis, and I think this is key in our work. And but econometric analysis is not really only an instrument. I mean, you cannot only apply an instrument and wait for the answer. Economic analysis goes econometric analysis goes hand in hand with economic reasoning. So I think a very important step in the process is, say, if you are trying to understand, which is most of the time the case, if you are trying to understand what is the impact of a given conduct on prices, so you have to understand the price formation mechanism. And in order to understand the price formation mechanism, the preliminary step, which is very important, is to try to understand what are the key determinants. What are really the variables that explain the evolution and the dynamics of price formation? Because if you fail to do this properly, the problem is that when you run your estimation, chances are, or very likely, your estimate about the alleged overcharge is going to be biased because basically you are attributing to the conduct effects that are not due to the conduct, but that are simply due to the fact that you are not including as regressors factors that you should be controlling for, and you are not. Okay, so this is a key step in the economic analysis. And the third dimension in which I think we play an important role is in cases in which you have direct and indirect consumers. Basically, it's very important to understand whether the direct consumers passed on alleged overcharges to the final consumers or not, to the indirect consumers or not. Because, of course, I mean, this plays a very important role, depending on who is claiming what, to understand what you effectively supported in a given, as a result of a given conduct. So these are, for me, the three main areas. Now, I would like to highlight that while trying to do the best we can along these dimensions, there are some challenges, and there are 3 or 4 issues that I would like, if that's okay, to highlight here, which are the main challenges that I think we face during this process. One, which I mean, it's not very often mentioned, but I think it's extremely important, is that in many cases, what happens is that the damage or the harm which is inflicted on a group of victims by a given conduct is not distributed in a symmetric way. It's not equal. Okay, so there are cases in which you have heterogeneity of harm, and in those cases, you have to precisely identify the segments of victims that you are facing, and to try to disentangle what is the precise effect of the conduct on each of them. The second thing I would like to highlight here as a challenge is the fact that more and more we are facing claims and class actions in markets which are highly dynamic, technologically driven, and in these kind of dynamic markets, I think it's a mistake to focus the discussion mostly on price effects, price and quantitative effects, because in this kind of markets, what you have also is for sure an effect on innovation, on product differentiation, which are more long-term effects. And in order to understand the overall impact of a conduct on a given group of entities or consumers, you have to fully understand price effects, but non-price effects as well. And sometimes they go in opposite directions. And then you have to understand what is the net effect of the practice. And this is a discussion that reminds me a lot what happened for many years in merger control. I mean, for many years, merger control literature and the merger control enforcement in practice, so people were only focusing on price effects. And only recently, the discussion of innovation came to the table, and now you have related discussions like, okay, then the antitrust authority cannot only look at one-step deviations from the current market structure in terms of price effects. It has to have to embark on an analysis which is more long-term. So, but how many years should you take into account? I mean, I don't know the answer, but clearly, what I think it should be done is to try and be a bit more forward-looking and less myopic in the analysis. The third note that I would like to stress here in terms of challenges for our work as economists is the fact that, I mean, we have several claims now related to technological sectors, digital platforms. These digital platforms work in two-sided markets, and basically these are situations in which a given platform puts in contact users on different sides of the market. And in these kind of situations, again, price effects, well, first of all, you don't have a single price. You have a price which is charged on on each side of the market, okay? And the definition of prices on each side of the market is not independent on what you are doing on the other side of the market. Secondly, these are markets which are highly characterized by strong cross-group network externalities, network effects, okay? And on the top of this, in these kind of markets, the economics literature has clearly shown that basically, when you are setting a price, you don't set a uniform price on different sides of the market, because usually you are facing very different groups of users on both sides. You tend to adopt what I usually call biased pricing structures. So you have a higher price on one side and a lower price on the other side of the market, okay? All this related to the discussion of getting both sides on board and so on. But by so doing, I mean, if you are specifically concerned with a group of users on a specific side of the market in which the price has increased, likely what happened was that on the other side of the market, the price has been changed as well. And if it lowers on the other side of the market, you increase participation on the other side of the market, and this is going to induce network externalities on the side of the market you are focusing your attention on. Again, you have to take all of this into account and to try and understand what is the net effect. Last note on challenges. Well, I'm not sure I should say that, but I will take the risk. I think, damages estimation is not an exact science. This is for sure. Okay, this is related to at least two types of issues. Oftentimes you have experts on both sides of the market presenting reports with completely different estimates. This is normally related to different data sets they are using, different methodologies, different definitions of the variables, and so on. You have usually fights between experts on both sides, which are filing reports subsequently. A report, and then there is a response, and there is a response to a response, and so on. And you have a judge in the middle. Especially in competition claims, you have a judge that basically wants to decide what shall she or he do in such a situation. And in a number of cases recently, what happened was that the judge simply discarded the estimates of both experts and decided to go for an informal estimate and apply it to the case. And I think this is a very risky approach, because this is completely in contrast with the objective of the damages directive, which aims at basically compensating the victims for the actual harm. So I think we should, as economists at least, we should think about ways and methodologies which improve the efficiency of the process. I think, at least in our case at Compass, we are happy to, whenever we submit a report, we are happy to submit as well a data package with all the data that we use, the codes and so on, for transparency, allowing the other party just to replicate our analysis, perform robustness results, and so on. So this is something that I think economists can do instead of hiding the data that they are using the best they can. But the court, they can play a role as well. The courts can play a role as well. Because the one thing that the judge can ask for is that for experts, for instance, to sign a joint report as well with the facts that they agree on and the facts that they disagree on. And this is I think this would help quite a lot. And in the limit, like in some jurisdictions, the best approach for me would be hot tub. You just put one expert in front of the other, they discuss, and then the judge clearly understands better the situation. And that's all I wanted to say for this first introduction.
No, really interesting. And I personally agree with so much of it. Just on your estimation point, as I'm sure you know, we have the courts here very open to a sort of broad axe approach, as they call it, where you don't have sufficient data or sufficient detail. The court, quite frankly, sometimes has to come up with very broad assumptions and estimates on loss. And I think what we always try and do, we do predominantly defendant work, although not solely defendant work, but we try and hold the claimant's feet to the fire, precisely for the reasons, Helder, you've mentioned, which is this is all about putting money ultimately into the pocket of the person that suffered loss, and a sort of general finger in the air figure just isn't sufficient.
Exactly.
By the way, I'm also a fan of hot tubs. I've seen them work very effectively. I think just a quick point on a hot tub, it really depends on the caliber of the judge. If you've got a judge that is really hot and knows what they're doing and structures it well, it can be a really effective way at cutting to the quick on some of these issues. I've got two questions, if I may, and I'm conscious of time, as always, coming out of what you said, Helder. Firstly, just on damages, we are starting here. Bear in mind, a bit like Portugal, we haven't had full determination of these issues, so we're still feeling our way through the regime. We're starting here to think about how damages are distributed and in what order. And there have been a couple of settlement decisions here for relatively small parts of a claim, where the court has been accepting in principle of the funder, and I think this is fascinating, the funder getting money before the victim, if you like, because there's an acknowledgement they've invested heavily in the claim, they've got to get something out of it. And I find that extraordinary, that we're in a world now, the funder gets money before victims. Has there been any, and maybe this is a mix of Pedro and Helder, has there been any debate on your side about those issues, or is it just too earlier stage?
Well, I would say that it's very early. Yeah. We have been discussing that, and in these 2 days we have discussed between between all the persons that we have met, because that's a hot topic, and we have no idea how in practice. I mean, the Representative Actions Directive and how it was transposed to the Portuguese legal regime provides some answers, but I mean, no one has seen how judges will look at it, how will they estimate the funders' fee, and how the multiple of remuneration of the funder will work. How distribution will happen? No, absolutely no experience in Portugal whatsoever in that regard. So I think we are far from having answers, and it's difficult to run class actions, private enforcement in Portugal with this amount of funding without having any answer. I have no idea how funders look at it, because they are investing, but they actually do not. This is a very important question that has absolutely no answer, and if someone says that he has an answer, he's probably lying. So I haven't. So it's a big risk. I have no visibility, and I believe there is no clear answer at this stage.
Helder, any thoughts on that?
No, I fully agree. I think this was also discussed in previous panels here as well. I think we are very far from a final answer on this. Just on a personal note, I find it very odd that the funders get paid first, because I mean this is a risky business. They know what they are doing, at least I think the ultimate goal of these actions should be to compensate the victims if there is a damage to be compensated for. So inverting the priority here seems maybe not odd, but at least fascinating to me.
Yeah, I mean, if I was a betting woman, which I'm not always, I would say I'm not sure. Some claims will, let me caveat, but I'm not sure these claims are going to convert into putting pennies and pounds or euros into the pocket of the consumer. Because I think there are some indications, particularly off the back of the settlement cases I've mentioned, where people aren't coming forward in the class to say, oh, that's interesting. I'd like my £25. So I'll maybe prove wrong, but I think in the end, it'll be very interesting to see what actually happens. Quick question again, if I may, coming out of what you said, Helder, is that, as I said when I talked about our regime, because of the certification battle, which I don't think is a hurdle you have to overcome in Portugal, Pedro, yeah. But because we have to grapple with it. The Economist has that starring role very early, and one of the questions tactically is how much of your legal or economic argument do you show at that early stage? Just so I'm clear, do the issues that you and Pedro grapple with, I assume just from what you've said, is they play out later, really, in the context of a defence?
Sure.
Or is, yeah. So it's just an interesting point that all of the very good points you're raising play out much later in the proceedings when you compare it to the UK.
Yes, here for sure, it's later in the process, yeah.
Fascinating. Okay, well, we kind of know where we are. Helder's talked about his work on working out the past. We're now going to go to the future and spend the last 5-10 minutes perhaps thinking about the future. What do we think we're going to see? We're all of us dealing with regimes that are still at a very early stage. What do you think the future holds, perhaps starting with Pedro, in terms of what's coming down the pipeline?
Well, I think the economic discussion will become interesting in the short future. So we'll start discussing not only direct damages, but indirect damages, umbrella effects on the Portugal. We have a lot of actions in Portugal claiming umbrella effects. So I think that will become interesting, because we will see competitors being drawn to the discussion because of the umbrella effects, either if they want it or not, but I believe that we will see that discussion happening in the next years. We recently had, as I said, a hub and spoke set of actions that were filed in the last 30 days or so, and I believe these discussions in that type of case will even be more interesting than they have been until this moment. And then from environment point of view, I think that it is difficult that the association that has been working in Portugal, we basically have one association that is been pushing all these competition claims, is left unchallenged by another association. And the interesting part will be how various a set of associations working side by side will do. Will they compete for the claims? Will they start standalone claims even at an early stage of the infraction? Will they file even riskier claims? Will they be funded? So I think that this will become interesting because Portugal is for sure an interesting place because of the opt-out regime, because of the way we structure our civil proceedings. So defendant has to put all the defense at an early stage of the proceeding. So it may be an interesting place to test some theories against Apples and Googles and those big companies. And we'll see what happens with competing associations for these claims and what funders will do. I think it will become interesting.
Helder, what do you predict with your crystal ball?
Well, I wish I had one. So
Me too.
I fully agree with what Pedro mentioned. Maybe I would add a few notes, 2 or 3 notes. The first one is that, I mean, tech platforms, they have been facing increasing scrutiny. So I suspect that more and more claims will be related to technology sectors. And within this set of future or possible claims, there is a subset which is related to data. And we at Compass Lexecon, we have been working on some cases involving digital platforms in Europe, in which we have been involved on very interesting discussions about what is the real economic value of data, privacy issues, the relationship and the dynamics in the interaction between platforms, advertisers, content providers, and users, of course. So this is clearly something which will keep on growing in my view. Another area which I think has not been mentioned very much so far, but in which I suspect that there will be something in the close future, is the emergence of claims related to labor markets, because we have been witnessing some anti-competitive practices being caught by antitrust authorities related to wage fixing, but also more complicated agreements like no-poach agreements, at least in Europe and in Portugal as well. So I suspect something along these lines will come as well, something related to this. This is for me a fascinating area as well. Because it's actually surprising that the antitrust authorities are devoting attention to labor markets so late in the process, because it's clear that labor market and product markets are go hand in hand, so they are very much related to each other. So what we do in one market affects the other market. Sometimes the effects go in opposite directions. For instance, the no-poach, one of the no-poach agreements type of argument is this argument that is, of course, okay, we have restricted workers' mobility with this type of agreement, like decreasing the outside options of the worker, and this allowed us to pay lower wages, but some of this benefit was transferred to the product market because consumers will benefit from lower prices. So again, this is a clear example in which you have one market in which the wages are decreasing, so penalizing the workers allegedly, but then you have a positive effect on the product market. So this is interesting to me because, again, it's a bit like it's related to this story of direct and indirect consumers. So you have a first-order effect on one market and a second-order effect on a related market. And in order to understand the complete picture, you have to evaluate what happens overall. And then there is also a problem of what is the objective function of who is looking at this. I mean, are you looking at the net effect of this? So is it okay to penalize workers as long as the consumers benefit more than compensates for the loss of workers? Shall we look at each set of players, so to say, or interested parties differently? I mean, this kind of questions I think will be on the table soon. And as a last note, this was also mentioned here several times during the previous sessions. I think we will see an increase in claims involving multiple jurisdictions. This is for sure. We are already seeing that.
Yeah, I have to say, I have really not thought that there was a nexus between the no-poach wage fixing angle and the sort of consumer-driven class action, which is really interesting. And we have, as I know you know, sort of several CMA-driven labour market investigations. And I'd always assumed and hoped they were somewhat sort of isolated, a bit of a trend that was going to fall away. But I absolutely see your point about the relationship, the network effects point. There's so much to. It's such a shame we can't have a drink, a chat over a drink, but another time. I'll summarise with some observations on the UK side, perhaps, which I think pick up points Helder and Pedro have covered. So we've had a process of heavy procedure, certification, the role of experts, how the CAT manages its case management powers, and we're now moving to a phase of substance. So the trial that we had at the end of last year, we're going to get judgment on that in the next couple of weeks or months. And I think that'll be really interesting. Obviously, it's its own case, but it'll be the first time we see how the tribunal is going to judge on the substance. And critically, all of those knotty points that you touch on, Helder, in particular, around damages and distribution, that's going to be determined in that judgment. It's not a case that's been split out, as far as I know. So we're very, very tantalizingly close to working out what's going to happen on the substance. The other interesting point is the swing, as we've all touched on, away from enforcement to private litigation, I think will continue. But we are seeing in this jurisdiction sort of regulatory intervention. So in, I think, 8 or 9 of the competition litigation cases, both on the collective side and on the non-collective side, the CMA has intervened. And sort of outline the relevant area of law. There isn't time to cover it, but does that happen in Portugal, just super briefly, that the authority intervenes or has intervened?
Well, it has happened that the competition court tries to have the competition authority on board on cases. But as far as I know, competition authority is not interested in entering in private enforcement discussions. Probably it has not the means or the interest.
Ours is, because I think what the CMA thinks is they haven't got time to pursue all these cases, but if they can intervene and make a few meaningful points, they sort of achieve their public policy objectives. So perhaps it's an interesting point of difference. But I see more of that regulatory intervention. And then super lastly, to pick up points you've both said, there's now a huge swing to consumer enforcement. So the CMA has got this enhanced consumer enforcement regime that is on equal footing with the competition enforcement regime, same penalties, same risks. There'll be more consumer enforcement, and then, of course, as night follows day, we're now going to have pure consumer litigation. And there's a big question here about how similar is that litigation on the substance? How similar is it to competition law in the substance? And critically, where do those cases play out? Do they play out in the competition tribunal or somewhere else? And that ties in with some of the points around digital markets that Helder picked on. There's going to be a shift on tech and some of those consumer and digital markets issues. So the bottom line is we're all going to be busy for the future, feeling our way through. But I am conscious it's now past. But thank you so much for your insights, both of you. Plenty to discuss. And I'm only sorry I can't continue to chat, but it was excellent. Thank you very much.
Thanks to you.